Hello everybody and welcome back to Lysenko channel on YouTube. Lysenko is a federally registered trademark in the United States of America in Class 45 legal services. Today I would like to discuss my most recent article published on my website lysenkolaw.com. This new article is about a specific type of a trademark application in the United States before the United States Patent and Trademark Office. It is called Intent-to-Use trademark application. The title of my most recent article is Benefits of Intent-to-Use trademark application in the US, protecting intellectual property rights before any actual business is launched. That's the article, that's the title. And let's talk about it. What is an intent-to-use trademark application? There are two major types of trademark applications before the United States Patent and Trademark Office. It's use-based or intent-to-use. There are some other types, but those are the most common ones. Use-based and intent-to-use. Use-based application means that the applicant has actual business and is using its mark in commerce at the time of filing with the USPTO. Intent-to-use application, on the other hand, is used when the applicant does not have actual use as of yet, but has a bona fide intent to use its mark in commerce in the nearest future, usually within 2 or 3 years. So now, why would one be interested in an intent-to-use trademark application in the absence of actual business, right? So somebody could ask that question. And here's the explanation. Oftentimes, creative people have great ideas and smart solutions they come up with. They do research, make inquiries, and seek means of launching that new business. Sometimes they share their new ideas with other people to see how the public would react to that new brand or new product or new service, etc. Intent-to-use application in this particular situation could be used as a smart tool that would provide such individual with a peace of mind and protect against a potential theft of its intellectual property. Thus, it could be a smart strategy to file an ITU application first, secure the priority date of trademark filing with the USPTO, and only then start sharing that new idea or a prospect new brand with anybody else. Some additional information about intent-to-use trademark application. Even though actual use is not required at the time of filing, the applicant must have a bona fide intent to use its mark in commerce in the United States within a nearest future. Usually it's soon or within 2 to 3 years approximately. ITU application allows its holder to include a wide range of desired goods or services and limit them later at the time of actual use in the future based on the goods or services that are actually in use at that time. The key is the early date of trademark filing with the USPTO, which grants the applicant a priority date. If the mark is finally registered, it would have the priority date of such an early filing. That is the strategy behind the ITU filing. You secure the priority date. So one of the questions that could be asked, would actual use be required in order for an ITU application to register? And the answer is yes. Even though an ITU application allows one to file without actual use, evidence of use will be required in order to register. Thus, if an ITU application is approved and not challenged by a third party, there will be a deadline to file a proper evidence of use. Failure to do so could lead to a trademark abandonment. What if applicant is not sure if the prospect brand or a prospect new product would be successful? Sometimes an applicant could be reluctant to spend money on a new intent-to-use trademark application due to uncertainty in the success of that new idea or a product. Even though on the one hand it's possible to understand that hesitancy, this approach could be a double-edged sword. If that idea turns out to be a success that many people like and are aware of, there's a risk of an IP theft or even a good faith trademark application by a third party with which is either identical or confusingly similar, right? So therefore, if plans to launch a new brand or a product are serious enough to invest time, energy, and efforts in its research and development, it is probably worse to consider a possible ITU trademark application as well. And this is all about being proactive and think ahead of what can happen and secure the rights before those rights could be taken away by somebody else. What additional questions that could be asked and addressed here? What is the cost associated with an intent-to-use trademark application? Well, at present time, the official filing fee for one mark in one class is either $250 or $350, depending on the exact goods or services selected. So there are two options. It's TES Standard and TES Plus. Depending on specifics of the goods or services, there would be slightly less expensive or slightly more expensive. The filing fee is for one mark in one class. Therefore, if it is one mark in two classes, that's going to be twice as much. The fee is per class of goods or services. If mark is approved, an applicant is ready to submit evidence of use in an ITU application. There will be a $100 statement of use fee. If applicant desires to extend pendency of an ITU application for another 6 months, there is a $125 extension of time fee to be paid to the trademark office. This option provides one with a flexibility to continue development of a product or a service and continue to have its priority date secured as long as the mark is active and pending, subject to the final deadline to show actual use in commerce. Under certain circumstances, there could be additional expenses. For example, in case of a request to divide an intent-to-use trademark application into 2 separate applications, showing use for one of them and allowing the other to continue its ITU status, right? So as far as attorney's fee, it is separate and may vary depending on a particular practitioner. So now, how long does it take to have an ITU application reviewed by the USPTO? At present time, it takes about 4 to 6 months from the date of filing to have a new trademark application be reviewed by the USPTO. Then, if no issues are raised and it is approved, it should proceed to the next stage, leading to its trademark registration. Of course, if it is not challenged by a third party. Each further stage can take a few months. If applicant seeks a further extension of time, it would prolong the pendency of an ITU application until the evidence of use is filed with the USPTO. So generally speaking, intent-to-use application would take longer than use-based application simply because it does not have the evidence of use part from the very inception. As trademark is reviewed by the trademark office and it is approved, applicants still need to fulfill that missing part by submitting evidence of use. And therefore there's additional fee involved for the statement of use, and possible extension of time. And if the extension is filed, there's a fee for an extension. Eventually, it is pretty much similar at the end because it requires showing of actual use in order to register. Okay. What additional questions could be addressed here? Well, can an applicant convert an ITU application into use-based application? At certain stage of a trademark prosecution, it may be possible to alter the filing basis from an ITU to actual use. In addition, under certain circumstances, it may be possible to divide an ITU trademark application into a few separate use-based and ITU-based proceedings. And depending on the circumstances and specifics and plans of client in the future, sometimes one application could be filed, sometimes two separate applications could be filed. Sometimes it could be one ITU that is later divided into two separate ITU and use-based applications. Sometimes it would make sense to file two separate applications. One would be ITU, another would be use-based, right? It's all about strategy and being proactive and thinking about the what's the goal and when the use will begin, and what's the scope of use, depending of the range of the goods. A decision could be made as to whether or not to go with an ITU or a use-based application. What else? Well, is an ITU application subject to similar trademark prosecution rules, right? There's a slight difference as to the official requirements for an ITU application. So the question, what about the prosecution rules? Are they the same compared to use-based application? And generally speaking, yes. Even though evidence of actual use is not being analyzed at the initial stage of trademark examination for an ITU application, a trademark examiner may still refuse an ITU application on various grounds, such as genericness, mere descriptiveness, or a likelihood of confusion under Section 2D of the Lanham Act. So the rules here are pretty much similar, to the rules that would apply to a use-based application as far as its examination by the trademark examiner. Thus, even if we consider and file an ITU application, it is still a good idea to select a proper term that can function as a trademark. It is equally important to conduct a trademark search to make sure that the same or confusingly similar mark has not been already filed or registered with the USPTO. What else could be discussed under this topic? ITU application. Well, is it important to select accurate description of goods or services under an ITU application? Even though an ITU option allows an applicant to select a wide range of goods or services in the beginning, the applicant would be later required to claim only those goods or services that are in fact in use. Therefore, it is important to understand that including too many goods that are unrelated or too out of the scope of what is actually being planned to be part of that new business or project, it does not really make sense, because when time comes to show to file that declaration of use, it has to list those goods or services that are actually being used. Therefore, the idea behind including a wider range of goods at the very beginning is to include only those goods that the applicant reasonably may be using in the future and has reasonable intent to use, bona fide intent to use. So applicant may not know exactly at the stage of this initial development what exact goods he will have, right? So it is possible to include related goods, slightly goods that may be relevant, similar, but not really including everything that comes to mind, because at the end the goods under the ITU application will have to be limited to the actual use. And in addition, what's also important to note is that the provisions of new U.S. Trademark Modernization Act of 2020 make this requirement even more important, because failure to properly claim what is in fact in use could jeopardize the entire trademark registration on various new grounds of cancellation in the future. Therefore, always was the rule to claim those goods for which the applicant has actual use in commerce. Now it's even more important to follow that rule because of the additional provision of the Trademark Modernization Act, because now there are additional new grounds of ex parte examination that could possibly allow to cancel a registered mark if the goods or services claimed under that mark are actually not in use. Anyway, this is the topic. This is my new article. It's published on my website, lysenkolaw.com. Thank you very much. Check it out. Take a look, and I hope to see you all soon with a new topic. Bye.